Hi, everybody. I'm immigration lawyer John Khosravi. Thank you for joining us today live, 6 p.m. Pacific time every Wednesday for the last 2 years and hopefully much longer. Here to take your immigration or U.S. immigration questions and giving educational responses, not case specific stuff because we can't do that here. I just don't know enough about you to be able to answer questions like that. But we will be answering general questions about trends and things that we see in the U.S. immigration space. For those watching the live show, as I said, Wednesday, 6 p.m. Pacific time, you get a chance to win the free consultation raffle. So within the show, every 10 minutes, we announce one winner and give them the opportunity for a free 15-minute consultation, no cost. We'll give instructions when they're chosen or how to contact me about it. But to be able to get in the raffle in the first place, all you need to do is like and subscribe wherever you're watching this, Facebook, LinkedIn, one of the YouTube pages. We have several YouTube pages. You have a JK Law YouTube page, JK Clips, as well as on TikTok. So if you're watching that, just like, subscribe, and write consultation in the comment section. And my wonderful assistant, Kayla, will announce a winner every 10 minutes, and I'll name him off so we can schedule a time to talk about what's going on in your case in a private matter, which you can't do here. So as people are trickling in, I'm going to start taking your questions. But what I do want to say is that if you are interested in doing a fiance visa, a marriage visa, green card, something like that, first thing I would say is to learn what's going on with the process. And do that, you should download the Ultimate Marriage Green Card Guide, a free guide that breaks it all down. Download it. You'll be amazed how much information is there. That's what people who read it and then schedule a consultation tell me, like, wow, I can't believe you gave all this information for free. It really helped up. Dozens and dozens of people have told me they just did their case based on this book. Now, I can't recommend doing that, but they've got the information needed and had success. And they call me and tell me, hey, thank you. I appreciate it. So God bless. That's what I'm here for. So with that, let's get it all started. All right, so we have some people coming in, some new people. The first question we have is 26 Support Humanity asks, U visa status not showing, says error receipt number. There's certain case numbers with USCIS that many times don't work. So if you have a case pending with USCIS, the immigration office in the United States, you get a receipt number. If you go to USCIS.gov, you go in that online system and input your number. And it'll say what your case status is. Now, even for cases that are normal, they don't always update that site, so it's not fully reliable. But certain cases just don't come out. I haven't handled a U visa case in 10 years, but I remember U visas, they're done because it's private information done out of Vermont or something like that. They don't always pop up on the website. I have a case in N470, application for preserve residency, that's not coming up either. And sometimes regular cases, I-130, I-485s don't pop up. So it's just a situation with the case number. It doesn't pop up. But if you have a receipt, that's good. Hopefully you have a lawyer that's keeping an eye on what's going on. Just got to keep better attention. But we have these kind of issues pop up with the case status. So unfortunately, that's the case for your U visa. And it's not unheard of. Thanks for your question. I wanted to practice hello from Missouri. Well, thank you so much for joining. It was a pleasure having you. We have viewers from all over the world, not just the United States, but we have them from the Philippines to India to South America joining us. So I want to thank everyone who's doing that from across the place. I was going to say what a wild situation going on in immigration and the timelines, but let's jump to this one. There he asks, how long does it take when you renew your residence card? So there's different ways of different kinds of residency, LPR, green card renewal case that happen. We're going to focus on the I-90, the application to renew your permanent residency. That's if you have a 10-year green card that's expiring or expired, and you submit from I-90 to renew it. There are no good timelines. So for example, in November of 2021, 2-3 months ago, I submitted a whole family's I-90 form. A month later, they got biometrics notices, the whole family saying, at least the appointment notice, saying, like in December, saying to come in January for your fingerprint. So filed the case November, December, they got notice to come for fingerprinting appointment in January. The family goes in January. A day later, the mom's green card's approved. But the dad and the 3 children, counted out, 4 people, nothing yet. So what we see is for green card renewals, typically average case between 3 months to 9 months is what we see. Could be faster, it could be longer. So these numbers are so all over the place. That's not very helpful. That's why, it's good to just generally know. But when you're dealing with immigration, a lot of times cases like this, it's just you shouldn't worry about timeline too much. What USCIS has done for green cards now when you file for I-90 is they issue an automatic extension notice that extends the green card for another year, and that should hold you over till it's done. If it goes longer than that, either they're messing up, they lost something, or your case has some issues, which they're doing deep investigation. So hopefully it doesn't come to that. But Neri, thank you for your question. Tanaji asks, how long do I need to stay at the current company after getting a green card based on EB3? 3 months sufficient? So it's a question I get typically. There is no answer to that question. It depends on your facts of your case and what the situation is. And so it's not something I could just say, do this or do that. It's not a formula. Later on, when you file for citizenship or N400 naturalization, they could say, hey, was this a real job? Did you just get it to get the green card and then it didn't work there? So it depends on the facts of your work history, your background, what you did for that company, and what the circumstances are you left if they want to get into that. So it's a heavily fact-intensive question. I can't just say this month or that month in a forum like this. So that's the long form of what I would need to look at to be able to answer a question like that. Thank you for your question, though. Tanji asks, is there any complication for future? I just explained that. So John Locke asked, does an N400 applicant seek admission during the naturalization interview? No. So seeking admission is when you try to enter the United States, essentially, or admission to become if you're in the United States, adjustment status is essentially if you're trying to enter the United States. So N400 has nothing to do with seeking admission unless you had long absences from the United States and had one entry they considered you seeking admission, and that could potentially pop up during N400. But the way you're phrasing the question is just incongruent. These things don't go together in that format. So you may be trying to ask something else, but that question really doesn't fit. But thanks for asking, though. Jordan, one regular asks, if I already have a B1, B2 visa before a U.S. citizen submitted an I-130, can I travel to the U.S. while an I-130 is pending through consular processing? So it's a question I get a lot. So essentially, this person already has a tourist visa. They have a marriage case pending, the form I-130, to prove the relationship is real. Once that's approved, they're going to set up an embassy appointment to get their green card. But this process takes like 2+ years right now. So in the meantime, the foreign person has a tourist visa, wants to come visit the United States, wants to come visit their spouse in the United States. Is that possible? Technically, it is possible. But the issue is when you try to enter the United States, you have to go through a port of entry. CBP on the Customs Border Protection is there. And they have to review and make a decision. Is this person really entering the United States to become a tourist, to temporarily hang out and not work and leave? Or are they actually entering as an excuse to be saying I'm a tourist, but really after they enter, they're going to file for a green card through adjustment of status instead of consular processing, because it's preferred to adjust status to be with your spouse in some cases. And so they're going to make a determination. So can you do it? Yeah, people do it all the time, but you just might have bad luck, or the officer, might not believe you that you're coming temporarily. There's a factors, and if they remove you from the United States, now if they give you what's called voluntary withdrawal, they say, listen, get back on a plane, go home, we'll call it even. That's not too bad. It's annoying. You have to, get on a plane, go back after a long flight. But if they think you're lying and they give you expedited removal, which is not that often, but it does happen, then you're going to be in a really bad situation, because expedited removal has automatic bans, and you have to ban on a reentry. Then you have to get a waiver. You potentially may be accused of fraud, so you might need a fraud waiver. In a marriage case, at least waivers are possible, but it gets really messy from there. So typically the answer immigration lawyers always give to their clients is, no, don't do that. And that was my answer for half a decade or more. But so many of my clients didn't listen to me and just came on tourist visas that I saw like, well, it's not that bad. It depends on the facts. So, if you come to the United States, but you have work back home, you have a job at home, and you have a return ticket, and the officer feels like, you're being honest, you're going to just be here temporarily, hang out and go finish the case out, consular processing later, it could be okay. But the thing is, it's up to the discretion of a CBP officer. And we never know who you're going to get. You might get somebody who wants to be difficult. Most of the time, they're not going to be like that, especially if you're honest. So it's a determination you have to make, how much risk you want to undertake, how much risk you want to take on. But it's up to you. Again, immigration lawyers typically say don't do it, but you got to give it a shot, do what you got to do. John Locke follows up, as an N400 applicant consider seeking during naturalization. How about a just applicant? Seeking admission is a different thing, John Locke. So you really got to go to say what you're trying to do. I don't want to talk about theory and stuff like that here. Singh asks, sir, can a caution from a 2010 in UK affect U.S. citizenship whilst I had an I-751 approved? Well, don't get ahead of yourself about citizenship. It could affect how you adjust status. So cautions are a thing in the United Kingdom, where police officers come and you do something wrong, and instead of taking you to court and stuff, they'll just issue a caution. It's like a ticket kind of thing. And I don't remember the exact cutoff year, but if you got one before like 2006 or 2008, it's not a big deal. But after that, if you get a caution, it's considered an admission to the crime that you committed. So then we have to look at what the crime is. So if it's like some not a big deal, it's not a big deal. But there's a lot of cautions for people caught with marijuana or something like that, and they get a ticket to let it go. That could be a really big problem. So the problem is, first, did you tell them if you applied for visas in the past? Did you tell them when you filed for adjustment of status or consular processing? The I-751 stage means you already got a green card. That means you may or may not have told them at the green card stage. That's the bigger problem. They could undo your green card. Now, citizenship, yeah, it could be a problem too. You need all the paperwork. You need to get the records for it. So it could be a really messy situation. So really consult with an immigration in private. There's a lot of analysis that has to happen. The court records have to be reviewed. The laws have to be reviewed. It's a deep analysis. So that's what you got to do in that case. Now, I do want to announce our winner of the free consultation lottery, Neri Esquivel. You came from the beginning of the show. Neri, take a screenshot of where you're watching this so I know your username pops up somewhere in the corner or something like that. It's you. And email me at info@jqqlaw.com so I know it's you, and I'll reply with instructions on scheduling a free 15-minute video consultation. For those just tuning in, what we do is we give out free consultations in the show. We have 2 more left being announced in 10 and 20 minutes. All you got to do is like and subscribe wherever you're watching this, whatever social media app, and just write consultation, and my assistant will name a winner, and we'll take it from there. And if you are interested in doing a marriage case, a fiance case, the first thing you should be doing really, the safe thing, a smart thing to do, is download the Ultimate Marriage Green Card Guide at marriageimmigrationlaw.com. That's marriageimmigrationlaw.com. All right, Afsal asks, USCIS changed my husband's visa category to IR1. Don't know what that means. IR1 means immediate relative 1. That means you're a U.S. citizen and your spouse got married to you, got a green card through you, and your marriage is over 2 years at this point old. So that's all it means. You don't need to do a I-751, or you might have had I-751 proof. Rob Barr says, how is the process of getting a green card removal proceedings married to U.S. citizen in the military? That's it's like asking me to read a book right now. So you need to consult with an attorney in private on that. Shota asks, hi, can you tell us shortly about the way from green card to citizenship through military service? So the system that they have for, you kind of jump ahead and get citizenship pretty quickly with military service, but that program hasn't fully been operating. Trump's trying to shut it down. I'm not sure what the status of the program is. There's been a lot of lawsuits if you do military service to get status. So I'm not updated right now what's going on, but it doesn't sound good. I haven't heard any positive updates on that program. Winner Duce asks, do I have to be at least 16 years old as a citizen to file for CRBA for my newborn? I'm sorry that you're not 16 yet and you have a child. I'm sorry, your image doesn't look like you're under 16, but I think you're saying, if you're under 16 and you have a kid, can your kid still get citizenship? I don't know. I got to analyze what's happening there, what your life history is, all that kind of stuff. Technically, to be able to transfer, it depends on what year your child's born and a lot of other factors. But if you're if you as a citizen have been living in the United States for 5 years, 2 of which are after the age of 14, then you could transmit citizenship through your child and get a consular record of birth abroad, like a birth certificate through the U.S. embassy. But if you're under 16, you haven't satisfied that. Its scenario is just so rare that I haven't seen it. This is something I have to do deep research on, and it might require federal court work to say, hey, this is not fair. But typically 15-and-a-half-year-olds aren't having kids, so this is just in a scenario that I could just off the top of my head tell you what to do. This is a weird one, so it's not something I can answer. Tanj follows up: can we transfer to I-140 without issue? Will there be concern changing job after getting green card? Curious. Tanj, these are 2 generalized questions. It depends on the facts of your individual case. I can't give general kind of stuff if something's going to be an issue or not. It has to be 2 case specific. We can't answer that here. But thanks for coming on and asking though. Bebo asks, which is faster, adjustment of status or consular processing? It depends. Sometimes consular processing, sometimes adjustment of status. It varies dramatically. John Locke asks again, why is an adjustment of status applicant considered to be seeking admission despite applying within the United States? It is what it is. They just call it that. So the adjustment before, historically, if you wanted to get a green card, this is like before 1945 or 1950, you had to leave the United States, do an embassy interview, and then apply for a secret admission into the United States as a lawful permanent resident. They added this adjustment of status program because they realized how difficult it is to force everybody to leave and come back. And they created INA Section 245A, or in particular, which added this component, which said if you meet more stringent requirements, you can apply for a green card while you're still in the United States. Essentially, they took this thing that's you're being admitted as lawful permanent resident after an embassy interview, making a smaller exception where you can do it in the United States, and I think that's why they kept the same terminology. If you really want to get into it, this has been something that's been argued a lot what it means. There's a statute called INA 237A1H, where if you lied in certain circumstances, you can still keep your green card and come get a citizen. And that statute specifically says applicants who are, I don't handle it, it's a removal kind of case. I don't do that, but it talks about if they're admission. And there was an argument of like, well, does this only apply for people doing consular processing for their green card, or does it include adjustment of status? Essentially, the way it looks right now, based on BIA, the appeals court ruling, it includes that. People do argue, but this is the back history. There's a lot more, but people have questions about actual stuff that can help them. This is just theoretical, philosophical stuff, so it doesn't really help that much. But thanks for your question. That's the background if you like that. Next question. Neri follows up. If you're a permanent resident, you apply for my wife who is under the DACA program, how long would the process be? Neri, this is too complicated. I don't know, because it depends. Having a DACA program doesn't lead to status. So it's going to be a long time because, okay, let's back it up. So if someone has DACA, they enter the United States either legally or illegally, with the permission or without, and they overstayed at some point. And because of that, they normally cannot file for adjustment of status. So they don't have to do consular processing. Now, if you are overstaying and you're a green card holder, then you have to do consular processing. Just getting the I-130 approved, the initial petition is going to take 2 years nowadays, and it depends on which country your spouse is from. And then it's COVID factors into it. And if there's waivers needed that factor into it, that could cause more delays, 6-1 waivers. So how long will the process take? There's just too many different variables here. It's probably going to take years, but you may not even be able to do it. Maybe you should become a citizen first. I don't know. So there's just too much going on here to be able to answer a question like that. You really got to sit with an attorney in private. And even our free consultation we're going to have is not enough time to really get into it. You got to analyze all your history, your paperwork, and review everything to catch it. I've had people get DACA and they filled out the form with a notary, and the notary missed a bunch of information, caused them to do fraud, and that creates problems because they filled out the paperwork incorrectly. So this is just too complex, but hopefully I gave some sort of overview for you. Coram asks, how can I contact the embassy? My father's case isn't live for more than 1 year at the embassy. 1 year pending at the National Visa Center embassy. This is for consular processing, getting your green card through the embassy system, is completely normal right now. If you want to contact the National Visa Center, there's a contact us page on their website for immigrant visas. You could contact them through that. But 1 year pending is no big deal now, unfortunately. Sandra asks, I like your interpretation of the law. Thank you, Sandra. I appreciate that. God bless. Neri asks, if I apply for my wife who is undocumented, how long? We answered that one. Coram asks, we already answered that one. SW asks, I'm an H-1B physician on a J-1 waiver job. Okay, ending late October 22. I ideally want to move into private practice. Married a U.S. citizen 1 year ago. Could I do an I-130 via spousal or I-140 via employer? Would I-130 better? Well, for I-140 through an employer, you need to have an employer filing for you. So if you have one, you can have that going, but you also have it through your wife. I need to see what's going on with the 2-year home residency requirement if you're an H-1B physician. You say you're getting a J-1 waiver job. It probably means you're working under appreciated area, getting a Conrad waiver. I can't say which one's better. It's too case specific. I need to know the facts of your case. Typically, I-130 is better, but if your marriage is new, your green card should get as a conditional green card, 2-year green card. So then you have to file another application. If God forbid something happens to your spouse and you're getting divorced, that could create more hassle. So maybe I-140 is better. So it's like there's just different factors you got to take into consideration: who your employer is, what country you're from. So if you're from India, you're doing I-140, that's going to take a heck of a lot of time. So there's just too many case-specific factors that have to be taken into consideration. So I suggest consulting an attorney in private about something serious like this. John Locke asks, if a consulate changes status of a pending visa from 221G to refused, will mandamus also still work? So 221G is refused. It's the same thing. Let me double check and make sure I'm saying that right. But they didn't. It's just a nominal change. It's the same thing. So will mandamus lawsuits still work? It may or may not work. You can't guarantee anything. Mandamus lawsuit, or really an APA lawsuit, what you're doing is saying the consulate is taking too long, embassy is taking too long to make a decision, and I want to force them to make a decision. Will it be a positive decision? Maybe not. Usually is. But this is just too case specific. You got to talk with a lawyer in private to see if it's appropriate for you. SWS with a current employer. Okay, so we already answered that. Well, SW follows up. Visa I-130. I'm going to stay in touch with the employment. Yeah, this is way too case specific. You got to schedule a private consultation to talk about this kind of stuff. It's not appropriate for. Mahakazi says, sir, do you have any information update from Humanitarian Parole? Yeah, bad news. It's terrible. They're not really approving things. They're overwhelmed with cases, and they raise the standards of what they're looking for. So you can always give it a shot for Humanitarian Parole. It might work. I've seen cases work really fast even, but it's not something I go in with an optimistic feeling. That's even if it's going to be approved, it gets approved in a timely manner. So SW112, with all the complicated questions about J1s and I-140s, I-130s, we could schedule a free consultation briefly for 15 minutes. It might not be enough time to go over all the stuff you need to go over, but let's do it. Take a screenshot where you're watching this so I see your username is you, and email me at info@jqqlaw.com. That's info@jqqlaw.com, and we'll schedule a private video consultation and talk about this briefly, see what's going on, and take from there. Muhammad Adnan says, I had an interview in 2014. I got a 221. Now USCIS approved my case and sent to the NBC. Do you have to pay NBC fee again, and do I have to interview again? I don't know what that makes sense, because you had an interview in 2014 and you got 221, which is you got refused. And now USCIS approved my case. Do you mean they returned the case to USCIS approved and sending it back to the NBC? If that's the case, it goes back to the embassy usually directly, and they schedule another time. So Mohammed, I don't know what's going on in your case to be answered. There's just like missing information there. 12 Anakan says, can I apply for expedite after filing for I-130 for husband? Anyone can apply. Whether it's going to be approved, I don't know. Jordan 8350 says, I heard that if you're in the U.S. on a visitor or other non-immigrant visa and you marry a U.S. citizen and file I-130 and I-485, the misrepresentation of non-immigrant visa is forgiven. Is that true? If there's straight up evidence of misrepresentation, then no, that's fraud. But if there's, they just don't bother getting into it if you do that. But this is too generalized. So you say any other visa or non-immigrant visa. If you come on a C or D visa, that may not be allowed. So I got to be careful how we get these generalized statements. But if you're a U.S. citizen and you enter and you get married, for example, file for a green card, generally they don't bother you about it, about accusing of misrepresentation. Now, there's lawyers on YouTube who have live shows who say the exact opposite of what they do. They're wrong, but they keep saying there's miscommunication. There's court cases on this, all that kind of stuff. Matter of Cabezos, matter of Ibrahim talked about this. So there's stuff to do, but again, I can't recommend someone just do this with the intent. It's about really if someone changes their mind. It happens all the time. People are waiting for their green card case to come to the United States, and they're at the airport. They're going to say goodbye, and it's heart-wrenching for them. They say, you know what, I just can't do it. I'm going to stay here. Or they come here, things are good, and then COVID happens. They're like, oh, man, I don't want to get on a plane to go COVID. Let's just do adjustment of status. So it really depends on the facts and how you always want to be able to show the intent wasn't there. But unless you get a really difficult officer in a U.S. citizen marriage case, I don't. There's not usually a problem for very few cases I've ever seen be a problem, if any. Deep Multani says, I just got asylum granted. Now, do I have to change or update my social security number? You don't have to, but it's better you always do it. Why not? You don't change the number, you just update it. So you update what's written on the card. Sonu asks, hi, sir, can you tell me the waiver, I-601 waiver processing time? Because I'm applying last year, April. Check USCIS.gov for processing times. Waivers for I-601 are taking over a year right now for most cases. Natalie asks, I got my T visa approved. Congrats. My husband got his EAD first. How long do you think it'll take to get my EAD? It's not up to me whenever USCIS gets around to it. John Locke says, thanks for answering all my questions, John. You're amazing. Thank you so much. I hope I wasn't too impatient or something like that. These are complex questions. These are the theoretical questions you're talking about. It's not something I really, I read it 10 years ago, 5 years ago, so I don't have the top of my head. I just do the best answers I can remember. But I study immigration law. I spent a lot of time trying to be the best at this. Definitely not the best, but close to it. So, thanks for your questions and being on the show. Try to just be the best immigration attorney I could be. So I'm going to ask DOL application for green card, how long it takes. It depends on your country of birth and the case and what kind of case it is. So consult with the attorney in private. Your employer's filing for you. Ask their immigration lawyer. Yasmin asks, can you expedite a 6-1 waiver? Most things can be expedited if there's a good reason for it, but it's hard, but give it a shot. SW says, thank you. We reached out, definitely. I look forward to talking with you. Sharmar says, are you talking about U.S. immigration? That's all we talk about here. I'll definitely check out the YouTube channel and JQK Clips channel for hundreds of hours at this point of immigration talk. Shreen Mari says, I applied my parents' green card June 2021. I have biometrics on October, but I've not received EAD. Yeah, it's going to take 8-10 months on average to get an EAD. So hopefully, let's say June, 6 months, 2 months here. Hopefully next month or two get it, but who knows. John Luck follows up. Asylum seekers are forgiven for unauthorized work. Are there other immigrants that are also forgiven? So asylum seekers potentially could not be forgiven for unauthorized work. There is statute says they may be subject to a 3 or 10-year bar for overworking. That's more complex than we need to talk about here. If you're marrying a U.S. citizen, usually unauthorized employment is forgiven. There's a statute for if you're applying for an employment-based EB1 through 4 category, EB1 through 3 and some EB4 categories called 245K that says up to 180 days unauthorized employment could be so forgiven. This is deep statute kind of stuff. I don't really want to get into this, but those are like the big ones that we usually see. If someone could get what's called 245I, those could be forgiven as well. These are people who had cases submitted for them or their parents, for example, in their parents' case in like the 90s or something like that, before 2000 or something like that. It's going to confuse everybody going into this kind of stuff. So I'm not going to go too much more on that. But thanks for your question, John. Good night, Attorney Khosravi, 29 Super C on regulars. Hope you're doing well. What could be the questions asked by customs to someone who has come to the United States to be a permanent resident by attending employment-based 3rd category? There's not much. I mean, they're just going to ask you about, they can ask whatever they want, but typically not much. It's just they got to review your paperwork and stuff like that. BD asks, I'm a citizen, but I have a conviction for credit card fraud. Can I still bring my fiance on a K-1? When you're doing a fiance visa, they go deeply into the U.S. petitioner, U.S. citizens' criminal history background, whereas on the marriage I-130, they don't. Now, rarely on I-130, they'll hassle you about that, even though they're not supposed to. So if you're having credit card fraud, that could potentially, you have to specify it and get the court record and certified records, all that kind of stuff. It probably still work. But things they look at for marriage or family cases kind of thing that problematic is if you have any, unfortunately, child sex charges or something like that, child abuse, and that kind of stuff under the Adam Walsh Act. I don't think credit card fraud could be one of them, but they can hassle you. I've heard people randomly be hassled. Generally not an issue, but I need to know the case itself and plan it out the best way to deal with that. Chinley asks, can you still apply for I-130 even though your visa expires in a year? Thank you. Chin, you're not applying for I-130. Someone's applying for you. If you have a visa, your U.S. citizen or green card relative does. And if your visa expires in a year, the visa itself, there's a lot of confusion going on this question, and we just don't have enough time to get into. I'm sorry. I tried rephrasing it, and then come back next week. We'll get into it. URGO says, is there any immigration reform news? No, not at all. I'm the only attorney on YouTube since the beginning said there's none going to be happening. If we're lucky, we'll get a little piece. I didn't get too many views, and my subscriber count didn't go up because of it, as opposed to the other ones that did say, oh, immigration, this and that. But if you want truth and reality from a political economist / immigration lawyer, you got it. You can get it right here. No immigration reform. I guess we got a couple more, but I'll take one more and then we'll end it up. Cass says, can a beneficiary receive food stamps medical for their 9-year-old son will affect their case? During Trump's time, it would. I don't typically handle these kind of cases, but they make exceptions for minor children. So it depends on what you're requesting and stuff. I just don't hand off cases. I don't want to say it. I think it's okay, but this isn't my specialty, getting benefits and stuff like that and how it affects the case. I typically don't have clients that need that. So that's that. Now, I do want to reference our winner, John Locke, who's very interested in immigration law and the technicalities behind it and the law and history and all that kind of stuff. John, just take a screenshot where you're watching, email me, and we'll get to chat about it more in private. Thank you. So I answer 2 more questions, and we'll take it from there. Muhammad Adnan follows up. I got a 221G letter. They sent my case back to USCIS. Then my wife got a revocation letter in September. Oh, shoot. So in these kind of cases, you got to resubmit the case because it's faster than what you're going through right now. That would have been what I would have recommended. But it's just too much going on. But once it gets sent back to National Visa Center. You kind of bypass the National Visa Center. You have to get updates of your documents, but they go to the embassy and update it there as well. But you want to update the documents on SEAC too. So this is something you really should talk with an immigration lawyer about. John Locke says, if an N-400 is denied, can you skip the N-336 appeal and go straight to federal district court? Yeah, it's possible. You got to see whether it's worth it or not, but yeah, you can skip that. The federal court has authority to do that in most cases. All right, everybody, thank you so much for joining us. That was great, lively discussion, constant good questions. I was really happy. None of sometimes we get some questions. It's just constantly the same thing, but a different kind of stuff. And, we talk about immigration law, and you got to, if you watch the whole show, you saw different aspects of how the law works, and you tested my knowledge on the spot. I got to answer these things. And I think that helps the show. I know my stuff, pretty well. But, you got to be careful. They'll brag and stuff like that. As soon as someone says they know something really well, you get hit with a question that you don't know, and it's very embarrassing. But that's just what I do. Try to talk about immigration all day, every day. Check me out on TikTok, Immigration Lawyer John. Check out the immigration talk show we have with Anya Segeva, my associate, talking every week. We have the Q&A here. If you're really into immigration law, I have a separate podcast that's for immigration lawyers called the Immigration Lawyers Podcast. Also, I'm the publisher and president of the Immigration Lawyers Toolbox, a training course for immigration lawyers. But we have a magazine that you can check out, a trade magazine called the Immigration Lawyers Toolbox Magazine. Just go to immigrationlawyerstoolbox.com/magazine, and you see what I do on my weekends when I have free time. Is I publish a magazine more about U.S. immigration and global immigration there as well. We have colleagues that help out with that kind of stuff. And having said that, thanks again, everybody. God bless. I'll see you all next week.